It is a document that documents the hopes and aspirations and accordingly tells us that how we should govern ourselves. We, the people of India, gave to ourselves the Constitution of India. We are the masters of the Constitution. We have to first understand that we have given this document to ourselves. So it is our document. We are the masters. And since if we are the masters, this document contains within itself the hopes and aspirations of none but us, the Indians, we, the people of India. And the moment we think that it is not serving the purpose for which it was, the document came into picture, we can amend it. I have a lot of problem with judicial overreach. I wrote a long article criticizing the courts for having come into the everyday life of Indians. That's very problematic. I think the PILs have made a mockery of the Supreme Court. People come up with all sorts of nonsense to the Supreme Court.
But on every given day, the law is so uncertain that the Supreme Court itself does not follow what it previously decided, and then it makes an exception to that. How are we to suppose? How are we as people, not me as a lawyer, we as people, ordinary people, supposed to trust to this institution? They can't follow what they said 10 days ago. So if they can't follow what they said, this is a very stark and strong evidence of how constitutional interpretation is taking place in this country. I don't see that why our judges keep searching. They go into a cross constitutional exploration across the Atlantic, across the Pacific. I don't see any reason. Yes, you can look at them, and this is something I realized only lately while studying in the U.S. They don't even look at any other country. Forget about even mentioning about any other country. Their constitutional interpretation is solely derived from their own values. Then why can't we look at our own values? Are our values, do we as a country are so value deprived that we can't look at our own values?
Namaste and welcome to another edition of the Bharat Vartha podcast. I'm Roshan Karyappa. Republic Day is just around the corner, and on this episode, we will deep dive onto the history and significance of the Indian Constitution, how it came to be, what were the various influences, and its relevance in the present age. We have two fine young speakers joining us on this podcast. We have Sarthak Raizada, who is an LLM student at Georgetown Law. Previously, he was a practicing advocate in New Delhi. Welcome, Sarthak.
Thank you, Roshan.
We also have joining him Shubhendu Anand, who is also a lawyer, and he practices primarily in the Supreme Court of India. He was earlier Chamber Junior to the Additional Solicitor General of India at the Supreme Court. Welcome, Shubhendu.
Thank you. Thank you.
Hey, so great to have you guys both. We've been meaning to do this episode for a while, and now it's like the best time to do it. So thank you again for being on the podcast. Let's begin with a little bit of context, right? So Shubhendu, I want to start with you. If you could talk about the circumstances in which the Constitution was drafted, right? It took 2 years and 11 months and 18 days to complete the final draft, and it had more than 2,000 amendments in that first draft itself. So what were the priorities of the new republic? And if you can also take us through who were the people, what really transpired in those conversations?
So, as you said, that the drafting of the constitution took 2 years, a little bit more than 2 years. But the Constitution of India is a document that carries a lot of things from the previous acts of the Government of India Act and the Indian Councils Act. So, to say that it is a very new document that the founding fathers created would not be a correct thing to do. It's a document that the Constitution is basically a document that documents the aspirations of the Indian Republic, and it documented the aspirations of the Indian Republic at that point in time. In 1947, India was partitioned. We were going through a very tough time in terms of the societal well-being, also in terms of economy. So we were in a very tight situation at that point in time. So the founding fathers were visionaries, to be least, that is the least I can say, that they were visionaries who could see that what would India be like 20 years, 30 years, 50 years down the line. Sitting at that point in time in 1948, 1949 and 1950, they tried to envision India as to what would be the aspirations of the coming generations. And that is how they drafted the Constitution of India is a document that has a lot of things borrowed from other countries. So I don't call it as something which is a lot of people say that no, people who drafted the Constitution, people who were part of the drafting committee or the Constituent Assembly, basically went abroad and took away whatever was there. No, I don't think that is true. They got the best practices from every place in the world. Every republic, every democracy, they tried to get the best practices, put them together, and tweak them in a way that would be helpful for the India of that generation and the coming generations. So they just did not copy paste things from abroad. A lot of things, a lot of rights, duties, the structure of our legislature and parliament, the way relationship between state and individual is envisioned in the constitution, the way the relationship between state and the union is given in the constitution, is very much in ethos with the Indian reality. So it is basically a work of research on the best practices from across the globe. It also takes a lot of things from the Indian Councils Act of, I think, 1861, 1891, the Government of and 1901. It takes a lot of things from the Government of India Act of 1935 and 1919 or 20, if I remember correctly. A lot of things are from there. But why? So all these things, the Government of India Act or the Indian Councils Act, were basically the documents, were basically the set of laws that were devised for the Indians. It was not a British act, although they were enacted and put into picture by during the British India time. But they were not British in nature. They were not American in nature. They were not Italian or Russian in nature. They were all Indian in nature because they were made for Indian people. So people who were in the drafting committee, people who deliberated upon it in the Constituent Assembly, aware of the situation that India was in, were also aware that how the future generations of India would be, and accordingly they put in everything that they wanted to put in into the constitution. There are things that they put in at that point in time. Later on, the political system or the democratic setup in the country thought that was not relevant. Later on, say for example, the right to private property was a fundamental right when the constitution was drafted. 30, 40 years later, the government of the day realized, and the parliament realized, that it was not correct to have for India to have right to private property, and they repealed it. So they made constitution in such a way that does not become rigid. Constitution is not a rigid document that cannot be changed. It is a document that documents the aspirations of the people, and the aspirations of the Indian people change generation after generation. So each generation has its own vision, its own aspirations, and its own set of ideas that it wants itself to be governed with. And accordingly, the constitution changes. We have had more than 110 amendments in the constitution. The amendments show that constitution needs to change with time, and it is changing with time, with new laws coming into picture, with new amendments coming into the constitution. So I would say that the founding fathers made the constitution a very flexible document. They wanted it to be in consonance with the aspirations, hopes, and vision of every changing generation of India.
Just to add two very quick points, especially about the circumstances in which the constitution was framed, Roshan. So when India became independent, there were two concerns that primarily weighed with the framers. The first was having a set of rights for the Indian people, because there were no such rights available during the British Raj. If we look at the document that was in existence before the Constitution, was the Government of India Act of 1935, that established a form of government, for a structure of the government for the people of India. It had no provision on fundamental rights. That was one of the main concerns that weighed with the framers on having a set of rights, which is now contained in Part 3 of the Indian Constitution, which we know as the fundamental rights. And those and many provisions, when we look at several provisions of the fundamental rights, they were mainly grounded in the nation's history and tradition. They were influenced by certain injustices that were rooted in the Indian history. Take, for example, the provisions regarding untouchability, where people were not allowed to enter places of worship. So, one consideration that weighed with the framers was provisions regarding fundamental rights. And the second most important consideration that weighed with the framers was bringing all the states together. Because as you would know, that before the constitution there were princely states and the provinces. Now these princely states, I will not enter into that debate because that debate will take a lot more time. Many said that these states were sort of independent and bringing them together was a big task. Leaving aside my disagreement whether these states were in fact independent or not, for the moment, it was one of the consideration before the framers that how do we reorganize these states, because in many of the states, as you would know, like Hyderabad and Jammu and Kashmir, there were parochial tendencies, secessionist tendencies which were prevailing at that point in time, and therefore integrating these states into the new Bharat was great difficulty that was before the framers, and a lot of concessions therefore were made, which over a period of time came to be heavily doubted. And yes, a lot of them have been remedied now recently in the past few years. Take, for example, Jammu and Kashmir, where 370 was just a form of a compromise. People like Shama Prasad Mukherjee, who played a great role in the formation of the first government, who was also a minister in the first government of Jawaharlal Nehru, he heavily opposed the inclusion of 370. He said that he asked the government, he challenged the government. He said that, do you want a republic within a republic? His words were prophetic in that sense. Over the period of years, we saw how certain movements, political movements, secessionist movements came out in Jammu and Kashmir, and it became a republic unto itself. So these two considerations, I believe, that the framers had in mind. And coming to the fact what Shubhendu said about that the Constitution is a living document, and that he made 2 points, that the Constitution is not a new document. Yeah, to that extent, I do agree with him that the Constitution is not a new document. Many people say it's a very revolutionary document. It is not. Let us look at what the Government of India Act had to say about the right of vote. People say that right of vote, right of franchise is something that came into the Indian Constitution for the first time. Yes, it came for a lot of people into the Indian Constitution for the first time, but we had a similar provision in the Government of India Act 1935, where objective criteria were contained in it, like educational status, property status, age was one of the objective factors which was already there. So voting rights were already there in the Government of India Act. We just extended it to everybody else when the Constitution came into force. Similarly, for example, you take the Indian Penal Code. I know it's not a constitutional document, but the Indian Penal Code created several offenses irrespective of the caste, religion of the person. If you go, let's say 500 years ago, 400 years ago, maybe 200 years ago, 300 years ago, people were still being punished on the basis of their caste and religion. But that stopped with the Indian Penal Code, and that same ideology got incorporated into the Indian Constitution. What are the equality provisions about? This is exactly what the equality provisions are about. So there is nothing transformative, and to that extent, I think there is requirement of a lot of evidence and more scholarship on this aspect, and I believe there is a lack of scholarship here in our country on this aspect. But I believe the Indian constitutional document is a conservative document, and to call it a transformative or a revolutionary document is a fallacious approach. Is evidentiary, it's a fallacious approach. And so far as the second aspect, which is how the Constitution should be interpreted, now that is something that has in over the past 7 decades or so has been influenced by various ideologies, underlying ideologies. And here we have to take into account the several constitutional actors that play a role in interpreting the Constitution. We believe right now, many people, in fact, many of the great lawyers in this country, great scholars in this country, believe that the Supreme Court's view of the Constitution is the final view of the Constitution. I disagree with that view. Why should the other two their interpretation should not matter of the Constitution? Their interpretation has an equal say in it. They have an equal say in the interpretation of the Constitution. And over the past 7 decades, one of the underlying ideologies has been a socialist ideology that has been used to interpret the Constitution. Take, for example, property rights. Property rights, if we look at the history of the property rights were incorporated into the Indian Constitution to preserve what? They were there to preserve the liberties of the people. Can we just think about it? Can we, without having any property right, associate with other people? Without having any property right, can I have free speech? No, I cannot. Can people associate? Will people be associating on the road? So property rights was one of the, and it's a Burkean concept. Adam Smith recognized it. It was there in the Magna Carta, and we borrowed it from there. And but this was not something that was solely a province of the American Constitution or the UK Constitution. We have a long history in this country of protecting property rights. So, and unfortunately, with the 44th Amendment, property right was, which was a constitutional right in a country, was made just fundamental right, which that was just made a constitutional right. It was abolished. That was just a very socialist ideology that motivated these concerns. And under the garb of introducing agrarian reforms, we have something called the ninth schedule in the Indian Constitution, which shields all these sort of laws, property laws, agrarian reforms, from any form of judicial review. Now, these were the measures that were taken during Nehru's government over the period of years. During Indira Gandhi's government as well, several laws came to be inserted in the ninth schedule, which had a damning impact on property rights of the people of this country. So I would say that over the period of years, and that socialist tendencies, socialist mindset has influenced our Supreme Court as well. They believe in what I call a freewheeling judicial policy making. They believe the constitution is what they think it is. They don't believe in what the constitution people think should be or what the framers thought it was. So I think that there has to be some sort of a movement in this country which stops judges from implementing their own policies, judicial policies, through judicial judgments when they issue judgments, because they take an oath to follow the constitution. They don't take an oath to follow the constitution they think it is. So I think to that extent, we need an approach, intellectual and both, and also political, that judges should stop this. They should stop implementing their own, substituting their own policies for the constitutional mandate. And if this doesn't stop, then this is the tyranny that this country is facing, even after 7 decades of becoming a republic.
I hope to get to that bit at the end, but then I mean you started off with that. That's something that we should definitely talk about, right? To what degree the Constitution still mirrors the hopes and aspirations of the people, and is it right for the judges to be the so-called arbiters or the interpreters of this, right? But as we talk about the history and significance and the circumstances in which the Constitution was framed, I'd like our listeners to sort of jog back their memory to, or rather jog back and do this thought experiment, right? Now, imagine that India is freshly independent, right? Some believe maybe 5, 10, 15, 20 years later than expected, right? Your per capita income is about 250 rupees, right? Per capita income is 250 rupees, and you have 584 princely states that you have to cobble together into this new republic, right? So as we talk about some of these challenges, some of the things that could have been better, I think it's really important to imagine the circumstances in which this whole grand experiment called India, some of the circumstances in which the Constitution was drafted, and the fact that nobody really gave this grand experiment, the right odds, right, that it would survive, and the fact that we've survived 75 years, not just survived, we're also beginning to thrive as well, right? Shubhendu, I want to dig deeper on the underlying philosophies and the constraints, right? Sarthak spoke a bit about it, and I touched upon a few different things, right, economically and politically. What were some of those underlying philosophies, the thought process behind drafting this constitution as such?
See, this is a very subjective thing, and I believe that what went in the minds of framers of the Constitution was that you have to give the rights to people. As Sarthak said, that one of the most important things that went in their mind was to give rights and liberty to the people of India, because they were aware of the fact that India was under invasion for almost 1,000 years, and people who were under invasion for 1,000 years needed voice, needed a free will, and that is what was in their minds, and that is why there is so much of thrust upon in the Constitution. There is so much of thrust upon rights of the people, but they were also aware of the fact that rights alone can become problematic, and that is why there is also a concept, there is also an insertion of fundamental duties, that while you are enjoying in the free country, you are with your free will, you are enjoying these rights, you also have a duty towards the nation. You also have a duty towards the society, because our society was very fragmented at that point in time. We had suffered partition. Almost 10 lakh people died in that. We had different princely states, like more than 550 princely states, which had to be cobbled together. So to ensure that there is an equal participation of people in the building of modern India, the framers of the constitution also devised a mechanism which they called the fundamental duties, which would ensure that everyone becomes a party to the development. You just don't enjoy the rights sitting at home, but you also contribute to the nation building. So the rights and the duties were balanced in this way. The second important thing that I think went in the minds of the constitution framers was that because India is such a diverse country, we have diversity based on religion, we have diversity based on language, region, topography, we have such diversities. So new states had to be carved out, new states had to be made. And a lot of thinking went into how the center state relationship would be, how the division of resources would be, natural resources like river waters. We still have disputes over river waters in north as well as in south. The Krishna water dispute is there, and then Satluj Yamuna link dispute here, which continues in the Supreme Court on the original side. So this was another very important thing that went in their mind, how the state and center relation should be there to ensure that the aspirations of the people, the local people from different states, should not be trampled upon by the aspirations of certain people sitting in another part of the country, which is geographically, linguistically, culturally entirely different from what that place is. And that is why the constitution framers ensured that the states have a lot of say in how they are going to govern their people, how they are going to govern their territory, and to minimize the effect of center in those states. Of course, there are things that were given to the center and continue in the hands of the center, which are important from the whole national perspective. Defense, you cannot give defense to states. You can give defense has to be with the center. There are things, but things like education, health, agriculture, all these things are very local to the states. And that is why the methodology to govern these aspects of people's lives were given to states. So center state relationship, rights and duties, and the third most important thing that I think was to balance the way the country is governed by making three different limbs of the governance structure, which is judiciary and parliament, which is legislature, and executive, to ensure that one limb of this democratic setup does not overpower any aspect of people's lives. Checks and balances were to be maintained through the other two limbs. And that is why I think today we proudly say that we have such a robust democracy, and we enjoy the fruits of democracy, and we go around the world claiming that we are the best democracy, oldest and the best democracy, only because the constitutional framers framed the balance of power in such a way that no limb cannot go haywire. There are always checks and balances. If the parliament does something which is beyond its power, which is beyond its legislative power, there is judiciary to check it. If executive does it, there is parliament as well as judiciary. So these are the three important aspects that I think that were in their mind while they were framing the constitution. One is rights and duties, the other is the center and state relationship, and the third is the balance of power amongst the three limbs of the democratic setup.
Just to add what Shubhendu just mentioned about, and the question, it relates back to the question that you just asked, what are the underlying philosophies that dominated the constitution? About that, there's something that my constitutional law professor said about the US constitution. I think it also applies to the Indian constitution. That the Indian constitution is a story where actors come and go, and all those actors, when they are involved with the constitution, either in framing the constitution, that is the parliament, or in interpreting the constitution, that is the Supreme Court, all of them will have certain narratives in mind, and it is those with those narratives that they will interpret the constitution. and governments will come and go. They will have their own ideologies, and therefore they will interpret the constitution according to their own ideologies. And there was only one ideology that sort of dominated for a major part of the our republic, that dominated either at the Supreme Court level or at the parliamentary level, the ideology that dominated the interpretation of the constitution. But the constitution does not advocate any one particular ideology. It's a document that is made for all forms of ideology. The constitution does not advocate one particular theory of the constitution. There can be several different theories of the constitution. And take, for example, this is something that I believe that has this aspect of the constitution and religion, the fundamental rights, which has seldom been paid attention either by the parliament or the Supreme Court. And that is a question of religious liberties. Right from the time the constitution became adopted up till now, there has been a constant threat to the religious liberties of the people. Take, for example, in 1950, we had a prohibition on bigamy only vis-a-vis Hindus. There were no bigamy laws for other religions. So the measure of social reform, if it has to be truly a measure of social reform, can it be so under-inclusive that it does not include other religions where bigamy is even more prevalent than the Hindu religion? So religious liberties to that extent were, for especially for Hindus, have been under great threat. The control of the temples is another major issue that faces us. And under the theme of secularization of all our religious institutions, especially of the Hindus, under the so-called principle of equality, religious liberties over the years has been eroded over decades, and the Supreme Court has paid no attention. And I don't think any sort of an interest balancing can take place in religious liberties and matters of religious rights. Take, for example, the recent Sabrimala issue that happened, the appointment of a Malayalam Brahmanical priest. Some people are advocating that this offends the equality provisions of the constitution. But will you eat away the religious liberty rights of the people under the garb of interest balancing what you think should be the religion of the people? Or should the people who are exercising that religion should be allowed to determine what their religious rights are? Should the court be doing this? So I think we need to take a relook at certain of the positions that we have taken with respect to certain fundamental rights. One of them is religious liberties. Greater protection should come from the courts for such rights. And yeah, and I think that the constitution is not meant just as a measure of reforming everything, secularizing everything. Equal importance has to be given to the religious liberties of the people in this country.
Yeah, I think it's such a difficult task, right? I mean, thinking about it, if you try to define things, to a certain degree, right, then you also, for every rule there's an exception, right? And if you go about doing this for as wide a sphere as as what the constitution has to cover, then obviously, you're going to come upon many multiple different such problems, right?
Yes, and
Uh,
and and when you create too many exceptions, you eat out the rule. That is textbook slippery slope. You keep creating exceptions to your rights, and those exceptions then become the norm, and which is exactly what has happened for religious liberty in this country. You kept creating exceptions that this is a measure of social reform, and those reforms were being constantly applied only to one particular religion. And now we are where we are.
So a lot of this also depended on the people that drafted the constitution, and of course, I mean, all of us, recognize Dr. Ambedkar as a father of the constitution, right? And some of us may remember Sir B. N. Rao as well. But there were also others, including 15 women members like Miss Sarojini Naidu, Rajkumari Amrit and so on and so forth, right? Sarthak, could you talk about some of these personalities, right, and what they added into the constitution? For example, I'm sure the women would have stood up for equal rights for one and all, and so on, right?
Yeah, so the one of the major contributions of Indian Constitution to creating equality was political equality for women. Women did not have voting rights before the Constitution came into picture. It was only for the first time that the Constitution created a right for voting right for the women that brought them at par politically with other members of the political community. Several of the female members of the Constituent Assembly, Durga Das, who advocated for reforms of political equality for women. And take, for example, other constitutions. It took so much time that for the American Constitution to have political equality for women, it came only in the 1950s. Before that, they did not have voting rights. Only men had voting rights. Only people who had property rights had voting rights. To that extent, I believe that yes, in the Indian constitutional document is also a feminist document which has uh, several provisions for the protection of the equality of women. Similarly, we have certain provisions, there are directive principles of the state policy as well, which talk about maternity, which talk about protection of women and children who were considered to be vulnerable sections of the population at the time of the framing of the constitution. So yes, I think that the in so far as Indian constitution is concerned, in a very good way, we had no debate, at least at the time we adopted our constitution, that whether women should be given voting rights or not. And unlike the American constitution, which is blamed that it was only a document that was framed by white males, we have no such allegation so far as the Indian constitution is concerned, because we had a sufficient amount of female representation. Yes, you can always say there should have been more, and there should be greater protection for the rights of the women, and that debate will always continue. But that debate will come as a measure of democratic reforms, and which is why we have the parliament, which is given the legislative powers, and we will have those reforms. That those reforms can always be debated. But so far as the ethos of the constitution are concerned, they were definitely dedicated and aimed at the protection of women.
Right. So, Shubhendu, do you want to call out any specific person's contribution here, or maybe talk about Dr. Ambedkar itself? I mean, how much of the heavy lifting, so to speak, did he do in the whole drafting of the Constitution?
See, I'll give you a brief background of the Constituent Assembly and the members of the drafting committee. Very brief. There are some interesting snippets that I would share with you. The Constituent Assembly and the drafting committee in particular had representatives who came from different walks of life. To say that all of them were scholars of Constitution and were great lawmakers would not be correct, because we were drafting a document that represented the hopes and aspirations of Indians at that time, keeping in view the vision and aspirations of the future generations. There were people who had served as ministers in the princely states. There were people who were jamindars. There were people who came from the landed gentry. Dr. Ajendra Prasad, despite whatever we read and say, he came from a very wealthy landed caste family from Bihar. We all know that he was the president of the Constituent Assembly. We do not know who was the vice president of the Constituent Assembly. The vice president was Sir H.C. Mukherjee, who was Christian. His name was Harendra Kumar Mukherjee, but he was a Christian. So he was the vice president of the Constituent Assembly. A lot of heavy lifting, when we come to the drafting of the constitution, a lot of heavy lifting was done by B.N. Rao. There is no doubt about it. Very few people know it. Few people are ready to discuss about this. But the reality is that a lot of heavy lifting was done by B.N. Rao. But everything was on the shoulders of Dr. B.R. Ambedkar, who was the chairman of the drafting committee. Chairman of the drafting committee had the responsibility to deliver that document. Now, who was doing the heavy lifting? Who was giving more ideas? Who was going around and looking at documents in different countries? Who was coming back and putting them all together and doing all this? Everything was done under the supervision of Dr. B.R. Ambedkar, and that is why Dr. B.R. Ambedkar is called as the architect of the Indian Constitution. But having said that, it does not diminish the contribution of other members. K.M. Munshi was there, and B.N. Rao was there. D.P. Khaitan was there. Very interesting name. D.P. Khaitan was a legal advisor to a lot of industrialists in the country, particularly the Birlas at that point in time. So pre-independence, he was D.P. Khaitan, came from the legendary Khaitan family who are into the legal profession from Kolkata. They are, in fact, the biggest family from Kolkata to be in the legal profession, I think. So D.P. Khaitan was the patriarch of that family, who a lot of people say that whose name was recommended by Gandhiji and Birla. But be that as it may, he in fact put in the ideas as to what would be the hopes and aspirations of the industrialist would be, and the businessmen would be, because our constitution has a lot of things on the taxes and how the businesses can be carried out and all these things. And I think DP Khaitan made a very significant contribution to it, apart from others. And DP Khaitan made contribution to other areas also, because he was a legend and he was a legendary jurist. The Constituent Assembly and the drafting committee in particular had people from different walks of life who contributed immensely to the making of the document.
Just to
And
add one point there, Roshan, because contribution, we're talking about contributions, and this is a very interesting trivia that was shared with me by Ketkarji, who is the editor of the Organizer, and she was also a member of the Constituent Assembly. Her name is Hansa Mehta. I'm sure you must also have heard about it. So she was also one of the representatives to the Dumbarton Oaks Conference that was responsible for framing the Declaration of Human Rights, which has often been relied upon by the Indian Supreme Court in interpreting the equality provisions of the Indian Constitution in light of the international framework, etc. So when the Declaration of Human Rights was being debated, what should be its provisions? So the first provision that came out was that all men are created equal. So it was Hansa Mehta, Hansa Jivaraj Mehta ji, who said that if all men are created equal, where do women and children go? So if the very wordings do not include women, so where will women go? And Hansa Mehta was also one of the members of the Constituent Assembly. So it was her contribution to the Declaration of Human Rights, which came in 1948, just before we adopted our constitution, that we have now in the Declaration of Human Rights what is called all human beings are created equal. And she was also a member of the who fiercely advocated for the rights of the women in the Constituent Assembly. So I think that even before this shows the Indian history, that how it paid respect for women. That even before the Constitution came into picture, we had women representing us at the international level, and who played such a significant role, not just in protecting the rights of the Indian women, but also rights of women across the globe.
couple of things that I wanted trivia, that the original drafting committee did not have N. Madhav Rao and T.T. Krishnamachari, TTK, as members of the drafting committee. In fact, Madhav Rao replaced B.L. Mitter, who in the early 40s was the Advocate General of Bengal, a great legal luminary and a great personality, and he resigned due to poor health. In his place, and Madhav Rao came, and T.T. Krishnamachari replaced D.P. Khaitan, who died in 1948, if I'm not wrong. Yeah. So, so these were the two people who joined later to the drafting committee.
Right. So at this point of time, I think let's talk about the scope and purview of the Constitution, right? Because something that we often hear about these days, especially, is this phrase called judicial overreach. So, what does the Constitution govern? What is out of scope? And I think here I would love to hear both of your perspectives. So maybe Shubhendu, you can start, and Sarthak can add.
See, I have a lot of problem with judicial overreach. I, in fact, wrote a couple of years ago. I wrote a long article criticizing the courts for having come into the everyday life of Indians. That's very problematic. The role of the courts, and especially the top court and the high courts, is not to govern the policy decisions, is not to adjudicate upon the on the issues of that people in their daily lives face. It's a constitutional court. The role is to interpret the constitution, and not to decide whether firecrackers should be banned or not, or whether alcohol should be sold within 500 meters from the highways or not. These are the things which should be left to the executive to decide. Parliament is a competent body to frame the laws, and executive is a competent body to execute these laws. Unless you find that there is an inherent illegality in the way the law came into being, or the law itself is unconstitutional, then you can go about changing it. But to suggest policy measures, to suggest that whether you can remove alcohol shop should be not 500 meters but 300 meters, or not 300 meters but 700 meters, all these things are very trivial things. A constitutional court should not get into all these things. To decide whether people should burst crackers during Diwali or New Year or their festivals should be left to the executive. The executive is a competent body. They are the people who implement the laws, who take penal actions. They are the ones. The Supreme Court has no business going about telling people that you should not burst crackers, or you should burst crackers till 10 o'clock, or you cannot burst crackers worth more than 4,000 rupees, 5,000. All these things are nonsense. I believe that these things should not, the Supreme Court should not get into all these things. It's a constitutional court. Get into the matters of constitutional importance, decide whether a law is correct or not, whether a law is constitutional or not, decide how the relationship between the individual and the state should be. These are the questions of importance. Uh, so that is the thing, and I'm a big critic of the judicial overreach. I'm also a big critic of the whole PIL system. I mean, I know my friend Sarthak might disagree with my take on the PILs, but I think the PILs have made a mockery of the Supreme Court. People come up with all sorts of nonsense to the Supreme Court, come and come with PILs that seek banning of vehicles on the road, or make it odd even
Efficacy of the
things.
COVID
And
vaccine as well.
yeah, COVID vaccine. I mean, things like that, and the courts end up entertaining those PILs, whether it gets dismissed or whether it gets judicial assent or not. That's a different thing. But so much of precious judicial time is wasted in deciding on issues that are so trivial, and that is why the Supreme Court should confine itself to being a constitutional court. Get into only those matters which are of very important, utmost importance, where the life and liberty of people are involved, where the nature and scope of relationship between individual and the state is involved. Things like that are to be decided by the Supreme Court. The Supreme Court is not here to dictate the daily public lives of people. So I have a problem with the whole PIL jurisdiction of course, it has served a lot in matters where the group rights have to be protected, and animals have to be protected, and things like that. I mean, it has served its purpose. But off late, it has become a very big problem.
This whole arbitrariness that we see, right, as a layperson, that we see the courts interfering in variety of these matters, is it like inherent in the constitution, or is it something that is has become personal, person dependent, that the authority changes and then you have different sort of actions taking place? What do you think?
So, regarding this concept of arbitrariness, first of all, it's not fleshed out in a very systematic fashion by the Supreme Court. In all fairness, many of the judges of the Indian Supreme Court themselves do not understand what exactly, as a doctrinal concept, arbitrariness means. And this takes me to the larger point here that is involved, that what is the Constitution about? If it is the document that governs the people who govern us, and let's look at it this way, that the Constitution is the document that governs the people that governs us. And what is it that governs the people? It is the laws that are framed by the people who govern us. It is the parliament. It is the executive, which is responsible for the enforcement of the laws. It is the judiciary, which is responsible for interpreting these laws. But the question is that what should constitutional interpretation entail as a matter of norm for either the Supreme Court or for the parliament? If the laws, let's take for example a very simple example, Roshan, that there are speed limits for the people. Those speed limits govern who? Those speed limits govern people like you, me, or Shubhendu, or any other third person, right? Now, if we as people cannot change the speed limits, what we think should the speed limit be, can the Supreme Court or its judges change the Constitution what they think it should be? Because it is the Constitution that governs their powers as well. The Constitution, unlike other constitutions of the world, has laid in express terms the powers of the Supreme Court. And over the years, these powers have been constantly expanded. The sole reason for the expansion of these powers is the reason where we stand today, which is why is there is a conflict between the parliament and the executive, and on one hand, and the judiciary on the other hand. the constitution, that the body that is responsible, the function of the Supreme Court is to interpret the constitution. It is not to make a constitution what they think is the best constitution, or what should govern the people. So this takes me to a larger point here, that it is the constant expansion of their own powers over a period of decades through constitutional interpretation that remained unchallenged, either by the parliament or by the executive, that has left us where we are today. That the Supreme Court constantly intervenes in matters of policy for everything. It is a question of life and liberty, and under the guise of life and liberty, they keep interfering in all sorts of policy questions. Take, for example, the efficacy of the COVID vaccine. Mr. Prashant Bhushan filed a PIL which wasted like enormous amount of judicial time. The court was listening to him, checking whether the COVID vaccine is efficacious or not. Should these kind of questions be determined by the top court? Is it even competent to determine these kind of questions? The answer is clear no. The scientific experts, doctors, medical research will determine that. It is not for the court, especially at such at an advanced stage, when the pandemic is, when there are so many uncertainties related to the pandemic. And take, for example, another situation, the Jallikattu incident. If Article 21 says that no person shall be deprived of his life, liberty without the procedure established by law, the Supreme Court is saying that person means animal. From where do they derive this interpretation? I am left to question myself. And under the guise of these kind of interpretations, they are hurting religious liberties of the people. We have a challenge that is a long-standing history and tradition for certain people to have Jallikattu. So it is these kind of interpretations that has truly left our liberties in danger. That has become a constant source of anxiety for the parliament. And the other, which is again a highly questionable, dubious interpretation on the basis of which the system of appointment of judges exists, that judges that it is the judicial branch that will have a primacy in the appointment of the judges across the globe. That there is no such trend. You have judges facing confirmation hearings, being confirmed by the Senate in the Supreme Court. I don't know what is so special about the Indian Constitution. You follow the American Constitution when it suits you, and you don't follow it when it doesn't suit you. So these kind of hypocritical standards have to be exposed. And if we don't expose these hypocritical standards now, then they have to be challenged. And I don't think there would be any better time than now. And confrontation is never a bad thing between the two branches of the government. That is exactly how I think the framers saw it. And if the parliament has taken one view of the constitution, it is the duty of the Supreme Court to respect that.
So Shubhendu, some of the challenges and constraints that we're talking about, right? I mean, I'm sure that there could be a precedence for some of this elsewhere in the world as well. In that sense, how does the Indian Constitution compare with its counterparts across the globe? As I understand, it's a lot more flexible than in the US. But in the US, I mean, we have also adapted a little bit of that federal structure, right? Giving the state the powers as well, and a good balance between the center and the state as such. So if you were to sort of compare the Indian Constitution with the rest of the world, how does it stand out? How is it similar?
See, I think Sarthak is the right person because he is a student of comparative constitution. So I think he is the right person to say that. But within my limited knowledge, I think our constitution compared to other constitution is on a very different footing for the simple reason that it is very flexible. Flexible in the sense that it allows for the parliament to amend it, and which I find is very unique. That the constitution itself gives the power to one of the branches that it has created for the democratic setup, the power to change it. And that is the uniqueness of the constitution, which you do not find in many other constitutions across the world. The parliament in India, uh, per few judgments, it is the view of the parliament is supreme. Per few judgments, view of the parliament is not supreme. But I think the constitution itself says that the parliament has the power to amend the constitution, and that is a very big thing that is there in our constitution. As far as the practices in US and other country is concerned, I think Sarthak would be the right person to talk about it. The other day, Sarthak was in fact telling me about how the practices are in the US, and what he is being taught over there. Sarthak, you may unmute yourself, please.
Yeah, very interesting thing I must mention, Roshan, that the US Supreme Court has never struck down a constitutional amendment. In our country, where constitutional document is not only the document that governs the parliament, but it also governs the Supreme Court, these kind of amendments are routinely struck down. And no such power, a power which is so drastic in nature, you have a constitutional amendment that is passed by three-fourth of the majority members of the both the houses of the parliament, two-third, I'm sorry, and then you have in some cases being ratified by the legislatures of the state. If such kind of constitutional amendments are being struck down by the court under the guise of judicial review, under by exercising powers of judicial review, I think we need to revisit what is the doctrine of basic structure. Because according to me, the doctrine of basic structure that was devised, formulated by the Supreme Court in Keswananda Bharti, was it's a very freestanding doctrine by itself. It depends on what an individual thinks should be the basic structure. And we need an alternative approach to a basic structure, because the biggest argument that comes in favor of the basic structure doctrine is how will we protect our rights. So the alternative theory in my view is the theory of natural rights, that first comes rights, then comes government. Because we had these rights even before the certain rights that even before the constitution came into picture. Yes, there are several rights that are created by the constitution for the first time, but several of our rights existed before that. And the argument that the government will violate the rights of the people is a fallacious argument in my understanding. And the reason for this is this, that all governments violate the rights of the people. There is no government across the globe that does not violate the rights of the people. But the question is that whether the government is violating the rights of the people on such a systematic and widespread scale that you need such a theory. If the answer is no, and if you think that the current constitution as it stands is the constitution that best protects the right of the people, and this is something that an individual should ascertain for himself, that whether this constitution protects my right or not, because all governments will violate your rights. And so far as the US constitution is concerned and the Indian constitution is concerned, there is a great deal of judicial restraint being exercised by the judges over there, especially with the current composition of the court. And take, for example, for the Indian Supreme Court to interpret a particular provision of the Constitution, let's say Article 21, they rely left, right, and center on foreign jurisprudence without looking at the underlying basis of the jurisprudence in those countries. The US Constitution, the current Supreme Court believes in the US that what fundamental rights should be protected. Fundamental rights should be those that are deeply rooted in the nation's history or tradition. But does our Supreme Court look at our nation's history and tradition to protect the fundamental rights? They don't look at it. They look at what the US is saying. They look at what the German constitution is saying. Some scholars say, let's look at Kenya as well. Tomorrow they will say, let's look at Mozambique as well. So this is not the approach that has to be followed in interpreting the constitution. We have to, and this is not something that's completely alien. We have certain judgments which has said that constitution has to be interpreted in light of its history, in light of the background of the country. But our judges are not interested in carrying out the historical examination. They are interested in what they think that the constitution should be. They think what should be the rights of the people. They will pander to certain woke sections of the community, and this is something that has to be addressed at a very systemic level. I give you one more example of this. Today, none of the judges of the Supreme Court, if they talk about inclusivity so much, they talk about equality so much, do any of these judges of the Supreme Court ever visit a tier 3 or a tier 4 city in the country and visit a law school over there to go and deliver a lecture? None of the judges do. All of them will go to Jindal Global University. They will go to National Law University, Delhi, because it gives them traction. But none of these judges go address, see what the situation of the students in those law schools are. They don't. So this is not inclusion for the sake of appealing to certain sections or presenting yourself to cater to a certain section which is concentrated either to Delhi or the metropolitan cities is not what inclusion means. This is not the idea of inclusion. And inclusion, you are not aware of the realities of your own country, and you're interested in what Germany says or Japan says on a given day. That is not how constitutional interpretation has to work.
So, Shubhendu, Sarthak has kind of passionately made that point right now, right? I mean, so I'll come back to the question I think we covered initially, which is, does the Constitution really reflect the hopes and aspirations of the people today? You know, or has it, has there been a schism of sorts, right, between the people and the Constitution? You could argue maybe caused by the interpreters or arbiters of this Constitution, right? But some people also, argue that this was embedded within the Indian law and the Constitution itself, right? I mean, that we do have a hangover of a bit of colonialism as well, right? And there's a tendency to see the people as natives, right, that have to be subjected to law and order and so on, right? What is your opinion about that?
Roshan, I don't think Constitution has outlived its purpose. And Constitution is not. Why do we think that Constitution, and a lot of people around think that Constitution is something of a sort of savior? See, Constitution is not a document which is your savior. It is not something which comes as what we call in our language Ramban. It is not a Ramban. It is a dog. We have to first accept that it is a document. It is a document that documents the hopes and aspirations and accordingly tells us that how we should govern ourselves. The constitution was not given by some, it was not given by some Akashwani, or it was not given by some ordained priest. We, the people of India, gave to ourselves the Constitution of India. We are the masters of the Constitution. We have to first understand that we have given this document to ourselves. So it is our document. We are the masters. And since if we are the masters, this document contains within itself the hopes and aspirations of none but us, the Indians, we, the people of India. And the moment we think that it is not serving the purpose for which it was, the document came into picture, we can amend it. And we have amended it more than 100 times. We have amended things that have even not been accepted by a large section of the society. Property rights, as we initially discussed, was not accepted by a lot of people in the country, but but the government of the day did amend the constitution. So it is a living document. It is a document that can be changed at any point in time if the society of that point thinks that the constitution should include what their current hopes are and what they think is going to be their hopes and aspirations in future. Be that as it may, I think Sarthak made a point on how constitution has to be interpreted the way the framers of the constitution wrote it, and not in a way that people sitting in courts think that it is their prerogative, the constitution, to interpret the constitution that they want to. See, if 10 people, 15 people sitting in a court decide that they would interpret the constitution that in a way that they want to, I don't think it is going to be the reflection of the hopes and aspirations of the people. Parliament, in its wisdom, which has the representatives from all places in the country, the people who sit in the parliament are people's representative. Basically, they are our representative. So they are representing our hopes and aspirations. They are the best people to think of an amendment in the constitution. They are the best people and competent to bring an amendment to the constitution, and at the same time interpret it, keeping in view the hopes and aspirations of the Indian people. Judges want to interpret the constitution in the way that they want to, and that is problematic, as Sarthak said. And that is where I agree with Sarthak on that point. Coming back to your question, whether it is reflective of the Indian ethos and culture or not, of course it is reflective of the Indian ethos and culture, because our constitution framers did take into consideration the nation's history, its culture, the ethos of the people. But The society changes every 20 years, 30 years. The society changes, and the constitution has to change with the changing society. I am someone who advocates amending the constitution per hopes and aspirations of the people, per the hopes of the and
But
aspirations
yeah,
of the
that
changing
should come
society.
democratically. That should not come from the Supreme Court whenever on a
Yeah, yeah, yeah.
given day how they feel about the Constitution. In fact, Roshan, the joke is that the Supreme Court itself never confines itself to its own precedents. On as lawyers, we see that there is no settled law. Either the Supreme Court will create exceptions, both sides will have judgments to support their case, which as should be, but on every given day the law is so uncertain that the Supreme Court itself does not follow what it previously decided, and then it makes an exception to that. How are we to support? How are we as people, not me as a lawyer, we as people, ordinary people, supposed to trust this institution? They can't follow what they said 10 days ago. So if they can't follow what they said, this is a very stark and strong evidence of how constitutional interpretation is taking place in this country. So I think this is something that must be challenged, and yes, this is something everybody should think about on our Republic Day this year.
Can you speak to the point that I made about some allegations that the Indian Constitution and the law itself is, has a bit of a colonial hangover, right? That it does not truly reflect the nation's ethos, right? And by ethos, I mean our, civilizational heritage and so on.
To be very honest, Roshan, as a lawyer, I find some rhetoric in this allegation as well, that the Indian Constitution is a colonial document. Yes, we looked several constitutions of the world. We took guidance from various other constitutions: U.S., Germany, Japan, Ireland. Our free speech provisions, I don't recall, it comes from a very freedom of movement. It comes from Germany, when at the time West Germany and East Germany were created. So yes, there we borrowed the text. We took inspiration from other countries across the globe, but the meaning of constitutional text always is indeterminate. If we look at our constitutional values, if we say, for example, freedom of speech and expression, these are only principles. We borrowed certain principles from other constitutions. But the question remains that how do these principles evolve in the Indian context? That is the question, larger question we need to look at. Yes, you can say in a certain rhetorical sense that it is a colonial document. And this is a question of great nuance. It's not possible for me to answer it on this podcast, but we only followed certain principles. Free speech may have different dimensions, it may have different theories. Free speech, for example, has one dimension, a marketplace of ideas, that every idea should be allowed to compete with with each other, and the truth will prevail. The government should not be allowed to determine what is true, what is not true, and on that basis they should not censor speech. On the other hand, we have the theory of self expression, that what clothes should people wear. So these are different theories that through which we develop these principles. But these theories should be grounded in the Indian context. They should be grounded in the history and tradition of the country. And one thing I must point out is that today our judges first determine the outcome, and on that basis they give their reasons. So they will definitely have an outcome in their head. uh, they will come to the court beforehand, they will have the decision already that they have made up, and then they will look for the reasons. So that is not how constitutional interpretation must begin. To remain faithful to the constitution, you have to start with text, and when text does not give you the answer, what do you look at? You don't look at America, you don't look at Germany, you don't look at Mozambique, you don't look at Papua New Guinea. You look at our history and tradition. If you so strongly believe, and there is one very good example of this, Justice Krishna Iyer's judgment in Manika Gandhi, when he was discussing the freedom of movement, he went into great detail of the Indian history. So this is not an approach that is completely alien to our constitutional interpretation coming from the Supreme Court itself. So I don't see that why our judges keep searching. They go into a cross constitutional exploration across the Atlantic, across the Pacific. I don't see any reason. Yes, you can look at them, and this is something I realized only lately while studying in the U.S. They don't even look at any other country. Forget about even mentioning about any other country. Their constitutional interpretation is solely derived from their own values. Then why can't we look at our own values? Are our values, do we as a country are so value deprived that we can't look at our own values? If the judges are capable of looking at the values of other country, I am sure they're equally capable of looking at the values of Bharat. So I think, yes, colonial hangover exists to the extent that you still want to follow what's happening in the UK. But if you have borrowed certain principles, you have to develop those principles according to your own values, histories, and tradition.
So, Shubhendu, you've mentioned that the Indian Constitution is a living document, right? To that end, it's been amended more than 100 times. What were some of those significant amendments to the Constitution that kind of shaped the times of the country?
I think the most recent one, if you ask me, I think the GST was a game changer.
The 101st Amendment, right?
Yes, it was a game changer. Some of the amendments that I see as problematic, the removal of the right to property, I see as a very problematic. For me, that was problematic. A lot of people would say that amending the preamble and adding things like socialism and secularism to the preamble was problematic for me, at least. So these are the things that I think were significant. I mean, let us not get into what whether they were good or bad, but I think these were significant landmarks, watershed moments. One of them was the very first amendment to the Constitution, the Free Speech Amendment, where my friend Tripur Daman Singh has written a book on it, 16 Stormy Days, on the very first amendment of the Constitution, and how Nehru and Shyam Prasad Mukherjee got into debates on it. It's a beautiful book. I think if your readers should, viewers should read that book. But the first amendment, as I said, was a problematic, and it was significant, and at least problematic for me, because you are barring the free speech of people on the basis of certain notions like public order. Public order is such a vague notion that it took Supreme Court more than 250 pages to write a judgment on what public order is. Kartar Singh is a judgment. Sarthak knows it. Public order, on the basis of what public order is and what public order would be. Morality, which is very so subjective. Morality is so subjective. What is moral for me may not be moral for you. Morality, public order, health, all these things were the grounds. These were flimsy grounds on which free speech was curtailed by Nehru. So it did not start with Indira Gandhi, as people think that amendments came into picture when Indira Gandhi became started her dictatorial regime. No, it came from the very first day of the framing of the Constitution, and Prime Minister Nehru became the Mr. Nehru became the first Prime Minister. He brought in the First Amendment, 1951. So these are these were some of the important. I can't recall all of them. I think Sarthak
Yeah,
might be.
so just very important thing, because he mentioned about the preamble. Very interesting trivia that our, especially the Supreme Court, and this is how we are also taught in law schools about the importance of the preamble and how it plays a significant role in constitutional interpretation. The interesting aspect of the preamble is that in 1946, when the Constituent Assembly was established, was formed after a form of indirect elections through the provincial assemblies, the Constituent Assembly adopted an objectives resolution. Now, those objectives resolutions set out certain broad objectives that the Constitution should pursue. And at that time, proposal was also floated that we should have a preamble, but that proposal eventually got rejected, because the framers said, because the view that emerged was that we can't have certain values even before we start debating what the final constitutional provisions would be. We can't bind ourselves to certain values at the very start when we don't know how constitutional text is going to look like. And therefore it was only after the constitution was finally, a majority portion of the constitution was finalized, that we adopted the preamble. So the preamble came after the constitutional text was adopted by the framers. And today, our judges look at it in the reverse. They start with the preamble and then they interpret the text. And preamble has, in all fairness, if you and I are to look at it, you will have a different notion of fraternity. I will have a different notion of fraternity. So these are very vague values, and these vague values will change from one person to the other. And the court has to adopt a very determinate yardstick to determine what these values actually mean. So it is completely doctrinally, I believe it's a very wrong approach for the court to start every constitutional interpretation with the preamble, because it was adopted after the text got adopted, and then we looked at all the various provisions of the constitution, and then we said that these are the broad values that these provisions reflect. So yes, this is and as Shubhendu mentioned, that we over a period of years, several constitutional provisions, amendments were enacted, and these sort of amendments came in the first 4 decades. And all of those amendments were a direct attack on the fundamental rights that were guaranteed to the people of this country, starting with the very first amendment, the insertion of public order. Because because Supreme Court in 1951, that this was the first time the Supreme Court was called upon to interpret free speech provisions, and the court said that, look, you can't restrict. There can't be prior restraint on freedom of press. We had the case of the organizer. This is the Brij Bhushan Lal case, where the Supreme Court said that no, you can't censor press on the basis of public order, and Nehru was adamant about doing so. People may call him that Nehru was a Democrat. He protected the values of the people. He did not. Mr. Anand Ranganathan gives a very elaborate account of the number of books that were banned during his tenure. I can't even. I mean, I can list out some of them, but someone can even Google that up, and you will know the kind of books that were banned during Nehru's regime. So I think
There's one judgment, there's Thapa judgment as well, I
yes,
think.
yes. So these are two landmark judgments that came that protected free speech. They said you can't restrict free speech on the basis, and the Parliament overturned it that time. Do you see these kind of amendments being made recently? No, there is no amendment that was made to fundamental rights chapter per se, except for the reservations provision. But that is an affirmative action provision. We don't see any kind of such amendments being passed lately. Who is actually protecting these rights now? That is a question that one must ponder over.
Now, another landmark thing that happened recently, which a lot of us do not agree with, is insertion of right to education as 21A. There are debates on whether it was right thing to do or not to insert right to education as a fundamental right under Article 21A. But it was a landmark thing. You may agree with it, you may not agree with it, but you have to understand that it is a landmark thing that came into our constitution. So we have amended the constitution. Constitution is an ever evolving document. It will evolve with the people. It is not a document that has the task that has been given a task to evolve us. So it's not something that has been forced upon us, and it is a document that will ask us to do this and evolve ourselves. No, constitution evolves with its people. The people who are following the constitution evolve it with them. So that's how constitution works. I mean, there are people who argue that no, constitution is a transformative document, and this document, that document. I do not buy those arguments. I mean, I have my own reservations. I have my disagreements, and I believe that constitution is a living document. It's an ever evolving document. It documents with the people of India.
On that note, I mean, when we look at the future, right? I mean, we're calling it the India decade, right? I mean, we're the fifth largest economy right now, and we're marching towards a $10 trillion economy. And things are going to be significantly different 10, 15, 20 years down the line. How do you think the constitution will kind of hold up? Do you think it'll continue to evolve as it has evolved through all of these 100 amendments and 70 plus years of history? And what are some things that you hope will change for the better? Again, there's a question to both of you. Maybe Sarthak, you can
Yes.
add, and then Shubhendu can
So,
follow.
so far as the progression of India as one of the largest economies in the world is concerned, so far as the role of the constitution here has to play, any if any has to be played in this, and this may get a little theoretical here, but I will try and make it as simple as possible for the people. There are two kinds of rights, or so far as issues that are involved when you are interpreting the constitution. One is a set of rights which you call the fundamental rights that are contained in part 3 of the constitution, and then you have let's say the freedom of contract, which is not there in the constitution and which is purely an economic concept. So I think, and the Indian Supreme Court, at least on this front, has been fairly consistent, if not completely consistent, that it has given a great amount of deference to legislative wisdom and executive wisdom in matters of economic policy. And I think that, as a matter of judicial policy and judicial restraint, is the correct approach. That economic decisions should be left to the elected branches of the government. The executive and the parliament are best suited to take into account the economic realities, the conditions, the demands, the needs of the people, the international market. And take, for example, the recent demonetization judgment. It's an excellent example of how judicial deference is paid to parliamentary wisdom and the decisions that are taken by the executive branch, or for that matter, the RBI. So if that is a policy of judicial deference that we need in the coming decades, where the Supreme Court is not interfering with the policy decisions on the economic front, so far as the other issues are concerned. For example, fundamental right, yes, the greatest protection should come from the Supreme Court. And I think one area that I am again, and I will again flag, are matters of religious liberties of the people. And the court should and must take a relook at protecting, giving robust protection to the religious liberties of various sections of Bharat. And so, as a matter of constitutional interpretation, I believe, yes, economic decisions must be largely left to the uh, elected branches, and that is a fairly consistent approach the Supreme Court has taken over the decades. So, to that extent, I believe, yes, our constitution is constitutional actors, so to say, such as the Supreme Court, have decently worked out constitutional interpretation in those areas.
Final word to you, Shubhendu, and maybe you could also suggest a few books that our viewers and listeners could check out to better appreciate and understand the Indian Constitution and law.
I'll just come to what Sarthak said, that the constitution. We hope that because the coming decade is India's decade, we hope that the constitution, the Supreme Court, and the three limbs of the democratic setup that we have in India pave way for a greater economic prosperity. They don't become impediments in the way of economic progress of India. We have seen what happened with the Rafale thing, and how Supreme Court got involved into the whole blame game, and whatever happened. Ultimately, the government came clean, but it wasted so much of precious judicial time. Having said that, I think apart from economic liberty, economic freedom that we are looking at in the coming decade, and very less roadblocks from the three limbs of the democratic setup, what I feel is that individual liberty, individual freedom is going to be very important. um, with economic, I mean, a person can enjoy the fruits of economy only if he is free, and enjoys his liberty, his freedom and liberty. So for me, the two big things that I look forward to, and hope that the constitution becomes a carrier of those aspirations, is individual freedom and liberty, and economic progress, and ensure that that the Supreme Court, or other branches, don't come in the way of individual liberty or economic freedom. So that's what my
Three books
as
I
far
will
as
like to recommend. One is especially for lawyers. I'm sure lawyers must already be aware about this, but for students, let's say, who may be interested in how what our constitution actually has to say, then it's the book by B. Shiva Rao. It was written soon after the constitution was adopted. So it goes into great detail about how each of the constitutional provision was adopted. And if we are to raise a generation of Indians who must know how the constitution is, they must definitely read that book. The second book I will recommend is In the Indian Conservative by Jayatirath Rao, who is one of the first people in this country who came out and said that, look, the Indian Constitution is not a transformative document; it is a conservative document at several levels. And Yeah, so these are the two books that I would definitely recommend your viewers to take a look at if they want to understand the politics and what the constitution actually has to say.
I think I would recommend two books to people. One, and one should read those books without any inherent bias. I think I when I read a book, I read it without any inherent bias. I call myself a conservative, but I read all sorts of books and without any bias. So one is Grenville Austin's The Indian Constitution, which will give a history of how the Constitution was framed, which is very important for all of us to understand that what went into the minds of our constitutional framers, how they came to conclusion on one subject or the other subject, and how the entire constitution was framed. So that is one book. And the other book that one should read is The 16 Stormy Days by Tripur Daman Singh. It's on the very first amendment of the Indian Constitution, and largely has the debates and the exchange of words and letters between Dr. Shama Prasad Mukherjee and Jawaharlal Nehru. So these are the two books that people should read on this subject that we are talking about right now.
Awesome. On that note, we come to the end of the podcast. When you think about something like the Constitution, you expect that there are going to be a lot of academic, pedantic aspects of things, and it may get boring in parts. But then this was a fascinating conversation. I think there's just so many intriguing aspects that the both of you brought up. And for me personally, I mean, I'm going to go and look at each of these things and go into that rabbit hole and figure out things to read, things to listen to, and watch, and so on, as I'm sure the viewers will as well. So it was well worth the wait. As I said, I mean, we've been waiting to do this episode for at least a year and a half now. So thank you, Shubhendu. Thank you, Sarthak, for being on Bharat Varta. And yeah, look forward to hosting you again.
Thank you so much for having us, Roshan. Thank you so much.
Thank you, Roshan. Thank you so much.